Good evening, everybody. Welcome to another episode of Conversations to Innovate, brought to you by the Innovator Trust. My name is Mandisa, and I am with the Innovator Trust. And this evening, we really will just be chatting about the POPI Act that is coming into effect as of the 1st of July. So we have our lovely facilitator with us this evening, Nicole from ENSAfrica, and so she'll be sharing a presentation with you. Please feel free to ask questions. Just a point of information, we have a Q&A chat box at the bottom there. That's where we would like for you to please pop all your questions in. And then we have just a general chat box, and there you can just put any comments that you would like to make. But for questions, please make sure that you put them in the Q&A so that we are able to see that. You are currently all on mute with your videos off. Please kindly remain that way. And please do note this session is being recorded, just as an FYI. And I'll hand over to you, Nicole, to take us through.
Perfect. Thanks, everyone. And thanks for making time on this chilly evening. What we're going to look at this evening is this awful act that's giving us all headaches, I'm sure. We're 8 days away from its go live implementation date. So we're going to try and keep it practical. So what I'm going to do is I'm going to cover some topics. I'm going to do these 10 things you should know about the Protection of Personal Information Act. It might end up being more than 10 things in terms of information overload, but hopefully we'll get through it. And what I'll do is at the end of each section, we'll stop the slides. We'll go across to some Q&A. Just to see what's coming up in terms of questions, and then we'll head back into the next section. So what are we going to cover this evening? So first thing we're going to look at is the application of POPI. And sorry, I call it POPI just because I've been dealing with it for 10 years and it's how I know it. Our information regulator has said that POPI has got some negative connotations in the Afrikaans language, and she doesn't want us referring to it as POPI. So she prefers that we call it POPIA or POPIA, but old habits die hard. So when does it apply to your organization? Let's look at its application, and when it doesn't apply, we're going to then look at who the key role players are. So who's who in the zoo in terms of who the relevant key people are that you need to know about. We're going to look at the role of the information officer or the deputy information officer, and who can go to jail. Very important question that a lot of people like to ask. Then we're going to look at the processing of personal information. So when are we able to do that? What are the rules? And we're going to look at the heart of this act, the 8 processing conditions, the 8 rules to live and die by. We're then going to move to trans-border transfers very briefly. And in that section, we're going to look at what the rules are around sending information out of South Africa. I'm going to briefly touch on prior authorization and the prior authorization applications. Just on that note, there was a bit of confusion in the last few days because the section of POPI that deals with prior authorization has been suspended in its application, one section of the Act, until February of next year. It caused a flurry of excitement with people thinking that the entire Act had been suspended until February of next year. That is not correct. Everything, lock, stock, and barrel, barring this one little section, comes in on the 1st of July. We're then going to look at data breaches and security compromises and what that means. We're going to look at the effects of non-compliance, and then I'm going to talk you through your must-haves. What are the things you need to have done or want to have done by the 1st of July? I see there are some questions and things, or one at least that's popped up in the Q&A. I don't know if it's relevant before we start. Yes, I see that someone's asking whether the presentation will be shared. We'll definitely share the presentation with you after this. So if you get bored and you want to go and get a cup of tea or some dinner, we'll share this with you. Okay. First things first, when does POPI apply to your organization? So let's do a quick deep dive in a history lesson into what's happened here in the past. Many moons ago, back in 2013, the Protection of Personal Information Bill was passed by Parliament. What happened there is that it's based on the EU directive, which for those of you who are familiar with European legislation called the GDPR, the mother act to POPI and GDPR is the EU directive. and GDPR is our sister act. And every time I say sister act, I think of Whoopi Goldberg in the movie. But in any event, it's been a long time coming, and it's been sitting on a back burner. And then suddenly, in the midst of a pandemic, and luckily not on the 1st of April, we would have thought it was an April Fool's joke. But in June of last year, it was signed into effect by the president, subject to a 12-month grace period. Every indication is that this is not going to be extended. This was confirmed again this week, in fact, yesterday, by the information regulator. Interestingly enough, the information regulator, her term comes to an end at the end of December. They've had 5 years in their seat already, can you believe it? And either she'll be reappointed or there'll be a new panel appointed, but certainly they're trying to prove their worth in the next few months that go by, and they're hitting hard at non-compliance, particularly in certain sectors. So they've indicated that the financial sectors and telecom sectors are high up on their hit list. We'll sort of see where it all ends up. So when does POPI apply? So subject to some exclusions, and I'll briefly touch on those. Anytime a responsible party, and I'll look at what that means as well, processes personal information which is entered into a record in South Africa, this act applies. Now we're going to look at the terms of processing and personal information and responsible parties. Entering into a record is really simple. You and I, if we're having a telephone conversation and we're talking about Mandisa's personal information, for example, or I say, oh, did you know, I think she's absolutely brilliant, and I'm sharing an opinion. In that instance, it's not being entered into a record. But the minute I write it down, I capture it, I send an email, I put it into a filing system, I do something like that, I'm then entering it into a record. Remember what we've said, 1st of July is our hit date here. It won't apply in certain instances. So for example, in our day-to-day personal household activities, POPI doesn't apply. It doesn't apply when information is de-identified. Now, de-identified has a very specific meaning. It means it can never be resurrected. It's dead. It can no longer be anything other than generic information not linked to a particular person or persons. It doesn't apply to police and courts and law enforcement and national security, and it doesn't apply to journalists. But otherwise, invariably, anything we do from a business perspective that involves personal information is almost inevitably going to be caught in the net of this act. So first concept, what is processing? You don't need to remember much, except that processing is pretty much any verb. Anything you think you can do with personal information will likely be processing. Importantly, even when we are restricting or erasing or destroying personal information, that constitutes processing. When we store it, when we update it, when we collate, when we send, when we transmit, all of these things are processing of personal information. If anyone can come up with ideas of when they think it's not processing, I'd love to hear it in the chat group. But generally, I think invariably almost every scenario involved with doing something with personal information is going to be processing. Right. Then we get to the term of personal information. Now, very interestingly, or perhaps it's a complication more so than an interest, but unique to South Africa, and that's because, remember, this piece of legislation is there to give effect to the constitutional right of privacy. And South Africa's constitution is very unique in its application, in that it doesn't only give rights to human beings, to you and I, it also gives rights to corporations or juristic companies. And so what we see reflected in POPI is that information or personal information is not just about living natural persons, but it's also about existing corporations or juristic persons. Now, that is not to be found in any other piece of legislation world around. And it creates a headache, and it creates a very strange area of law where, I mean, if you look at the definition here of what constitutes personal information, arguably, even someone's company corporation symbol, which is a trademark invariably, could be personal information. So how do we then intersect between our IP laws and data protection laws? We don't know what that's going to mean. In the practical application sense, what is it going to mean in terms of company information? But what it does mean is that anytime we deal with supplier, customer, vendor, whatever it is, information that relates to companies, it's not only those employees' information, it's also the names of the companies that become relevant. So you'll see on the screen in front of you, I've divided it up into two different colors, black and red. Now, the general rule in relation to the black information, and you can see it's very widely defined. I mean, views and opinions, ID numbers, email addresses, location information, all these things in black here. The general rule when we process this personal information is that we don't need the consent of the data subject in order to process it. We do have to have a lawful basis to process it, and I'll touch on that when I get to the 8 processing conditions a little bit later. But the general rule for the black information here is that you don't need consent. But the red flag items, the items in red here, and as I flip over to the next slide, those are called special personal information identifiers. Now, when we touch special personal information, we need to be incredibly careful. When we touch children's information, it's one step beyond special personal information. And the general rule with special personal information, and particularly children's information, is you may not process it unless you have consent. That means when we start touching on people's health information, race information, trade unionship information, very importantly, alleged criminal behavior, all of these things, biometric information where we capture facial recognition technology and we use fingerprints, all of these things, we generally need consent of the data subject. Now, there are some exceptions. Obviously, there will be. Where we're forced to process this in terms of law, for example, when we're dealing with our COVID stats at the moment, you're forced to process your employees' COVID information. In doing that, or visitors to your premises, in doing so, you don't need consent because the law obligates you to do it. Likewise, with BEE information, we're forced to process race information by law. There are also some other exclusions when it's needed for the performance of a contract, for example. So there are some carve-outs, but when you touch this information, please just be extra careful, all right? Say to yourself, do I need consent? What is my lawful basis for processing this information? And remember, with children information, it's a hard stop. You may not process children's information unless you have consent of the guardian, or there's a law, or you've got permission from the regulator. So when we deal with our employees and their beneficiary information, which includes children information, or if we've got a business that may relate to children, I mean, I've had a number of clients, for example, that do online learning platforms for kids. What do we do in those instances? Okay, we need to just remember we have to be very careful there. So let's look at some practical touch points. What does that mean for us from a day-to-day perspective? And then after this, I'm going to turn to Q&A and to chat. So if anyone has questions so long, pop them into the chat function. We're going to now deal with those after this. Interestingly enough, if we turn back to the definition of personal information, photographs is not mentioned at all. So that's very interesting. Under GDPR, photographs can be special personal information. And certainly photographs can be used for biometric information. They can be used for facial recognition scanning. A photo can reveal your age, your health, your gender, your marital status, your pregnancy status. Photos can reveal criminal convictions. It can reveal all sorts of things. So when it comes to photographs, we generally treat it, and this is certainly something that I do, is we treat it as if it is biometric information and you must have consent to process photos. So where we use photos, I mean, I had a client the other day that had an environmental campaign and they use a little girl sitting on a truck. Now the question was, can we use a child photo sitting on a truck? These are all sorts of things we need to think about when we use our staff photos from back in the good old days when we used to have functions and whatever else we had. Please remember you should get consent from your staff. CCTV footage becomes incredibly important for us. That is because CCTV footage is generally invariably used for criminal processing, so monitoring people for offenses. So you want to put in place a policy that permits you to use CCTV footage and to put up relevant disclaimers. We then get to things like WhatsApp groups. What happens when we use WhatsApp? What should we be sharing over WhatsApp? There's a whole lot that's going on in the market with WhatsApp. But invariably what we want to be doing with WhatsApp is managing what is communicated over those platforms. And remember, if it's a representative of your company that's doing business communications on a WhatsApp group, you may be liable for those if there's breaches. You don't want to be sharing confidential information or sensitive information or proprietary information. So these are all things we want to look at. Right, quickly turning to the Q&A. So I'm going to just pause the share and jump into the Q&A. Right, so I'm just going to run through the questions quickly in the Q&A here. Beverly, you've said, what is the impact on POPIA on SA ID numbers and company registration numbers? So ID numbers and company registration numbers are constituted as personal information. So that means for our purposes that POPI regulates how we deal with that information. So we have to treat that information in a POPI compliant manner, and we have to process it in terms of our 8 processing conditions. Hope that answers your question. It's going to be interesting with company reg numbers as well, particularly because so much of it is out there in the public domain already, whether or not that should be treated specially or with kids' gloves. Chris, you've said, if I pay but receive bad advice regarding POPI compliance from a consultant, is the person giving that advice also liable for any repercussions? No, the way POPI is structured, and I'll touch on it again when I get to the non-compliance, is it provides a strict liability or vicarious liability component for the responsible party. So the employees of the responsible party are going to be falling under the umbrella of that company. And so that company will remain liable for the actions of its staff if they've done something in contravention of POPI. Celestine, you said marketing is becoming a nightmare, working and training with youth, working around that is tough. I absolutely sympathize. I don't know if anyone's noticed, there's been a flurry of emails in the last few days, and I'll get to the raised hands now, that deal with people suddenly asking you for consent to process information and to market to you. And it's actually a short-sighted approach, because you really need to understand what direct marketing means insofar as Section 69 of POPI is concerned. And what that means in terms of when you actually need consent, because it's really becoming tough, and it's really tough to market to the youth. So really we'll touch on some of those aspects a little bit later as well. Chris, you're asking here about managing consent in WhatsApp groups. First thing I suggest you do is delete all current groups, appoint a new group administrator, and send people a link to voluntarily join that group. So don't add them to the group, send them a link to decide whether or not they want to join that WhatsApp group. And in that way, you've obtained consent insofar as those groups are concerned. There's many things. I could spend hours with do's and do nots on WhatsApp groups, but we're a little bit limited for time. There's another comment on using stock photos. If you're using stock photos, that's fine. It's for the person who took the photos, who's responsible for those photos, to get the necessary consents. What you may want to do is just get an undertaking from them that they have done so in a compliant manner. Another one, if you're advertising on WhatsApp using your personal number, but selling business products, what then? Well, if your personal number is linked to your business, it's still personal information, doesn't really change the application of the Act. Even though you're putting information into the public domain, POPI still applies to information in the public domain. And just remember that anybody that's dealing with your personal information from a company perspective would also need to do so in a POPI compliant footage. Jennifer, you've said here, CCTV footage. Can I give us notes on what we put in a policy? I'm going to touch on that in the next slide. And then Zoe, you've said you're an events company. How will this company affect what we do? And how we do it. So events companies, same rules apply to everyone, but if you're actually doing the direct marketing for events on behalf of your clients or customers, you need to then very carefully consider the direct marketing provisions under POPI. Very happy after this, if you want to be added to our mailing lists at ENS, there's my direct marketing pitch for the evening. Just pop your details over to Mandisa. We run direct marketing workshops on a monthly basis, and very happy to just extend an invite to you to one of those workshops. These are the way in which you can address these issues that we've just discussed. You can put in place a CCTV monitoring policy, and the CCTV monitoring policy will tell your employees and visitors to your premises, for example, that you'll be monitoring people and you want to get the consent of your staff. Remember, you don't have to have consent. You may have a different ground to process. It may be because of your employment relationship, but it's better to get consent. HR consent clauses will cater for that as well. And then you want to look at your CCTV disclaimer wording and put wordings up around your building that caters for monitoring. And we do that. We do advise clients on what to put in those things, and we do sell these as part of our toolkits as well. Then your internal and external privacy policies. We'll touch on it in a bit, but remember what you have to do is you have to tell the outside world, and that includes your staff, what it is you do with personal information. And that is found in your privacy policies or privacy statements. So where you use special personal information for any reason, you must disclose that in your privacy policies. Okay, I'm going to move on to who the role players are, and then we'll come back to another Q&A section. Right, so who are our key role players here? We've spoken about the data subject. The data subject is the party to whom the information relates. It's you, it's me, it's companies, it's corporations, it's our clients, our customers, our staff. Okay, so remember, it includes corporations. On the other side of the screen, on the flip side of the screen, we've got the information regulator. They are the watchdog. They will be responsible for enforcement of non-compliance, for monitoring compliance, for education and awareness. Their focus certainly at the moment is more on a stick than carrot approach, and we'll see how that plays out. Then very importantly are these two concepts that lie in the middle here, and it's creating a headache for the industry at the moment. The responsible party is the party who determines the purpose and means of the processing. Invariably, your organization is going to be a responsible party. You are definitely a responsible party vis-a-vis your employee information and your customer and client information and supplier information. You are responsible for that information. In Europe, it's called the data controller. This act looks 101% at the responsible party. There are three little provisions that look at the operator, but all the liability, all the obligations are placed squarely on the shoulders of the responsible party. It must comply with the act. It is liable if something goes wrong. Every responsible party, and remember, every company, including every company within a group, is a responsible party, and they must have an information officer appointed. You may also appoint deputy information officers, and certainly we recommend that you appoint some privacy champions and deputy information officers to share the load, particularly when you've got a large staff contingency or a lot of data you deal with. It becomes easy if you appoint deputy information officers across your business units or areas. The Information Regulators Office yesterday lifted the hard stop of 30 June for registration of information officers. For anyone that's trying to do information officer registration on the online platform, it's been an absolute nightmare. If you've got more than one information officer spread across a group, you can't register them. If you halfway through an application and it gonks out, it won't let you finish the application. There's been a myriad of issues with their platform, but they've said they're not going to penalize anyone if you haven't registered by the end of June, because they're trying to get their own systems in place. So you've got a bit more breathing room on that. I'll touch on the information officer next before I turn to the Q&A. Then comes the concept of operator. Now, the Act recognizes that a responsible party invariably is never going to do everything itself. We're always going to have a third party or a number of third parties that do certain things on our behalf. Now, remember, when I talk about people doing things on our behalf, I'm talking about processing of personal information on our behalf. I don't mean the guy that comes to fetch your garbage is an operator. Okay, he's doing something on your behalf. But if he's not dealing with personal information, he is not a POPI operator. Okay. Likewise, the mere fact that you are sharing personal information with another entity doesn't make that other entity an operator. Data sharing between two responsible parties happens all the time. For example, if you come to me as a lawyer, I am a responsible party and you are a responsible party. I will never be an operator, which means when you share information with me, I become liable for what happens to that information as you are liable for what happens to that information when it's in your hands. The law obligates us to put in place agreements with operators. That is because operators are an extension of us. They are doing something on our behalf with personal information. Some examples: payroll administrators, IT service providers. These are going to be operators in the true sense. We place personal information in their hands. They don't decide why that information is in their hands, what to do with that information. They just follow your instructions and within the parameters of what you tell them to do. You must put in place an agreement there, and you are liable for the actions of the operators. Identifying who's who in terms of responsible party and operator has become a headache. We keep hoping for the regulator to give guidance. They haven't. There is some excellent international guidance. Welcome to contact me after that for some of that guidance. But really, we're a little bit stuck because everyone is bashing out operator agreements, and I'm sure you've all received about 20 across your desks. I myself have received multiple ones where my clients have said, please sign the operator agreement. And I say, thanks, but no thanks. I'm not an operator. I won't be signing this. So what do we need to know? Look at these slides after the fact. If you tick these boxes, or if the other party you deal with ticks these boxes, they're likely to be another responsible party, okay? Flip side of the coin. If they tick these boxes, they are likely to be an operator. This is just to give you some practical guidance as to how you determine who's who. Not set in stone. This guidance comes from the UK, from the Information Commissioner's Office. Obviously, we're relying on international guidance here until we have local guidance. So the kind of things you're looking for in terms of things, an operator agreement, okay? An agreement with your operator, which can be a long thing, or a very short addendum to your existing agreements, which can come with a covering letter just explaining why you want this signed off. A data sharing agreement is an agreement put in place between two responsible parties. It is not going to be necessary in law to have this agreement, but it can be recommended. But your operator agreement is a must-have. Right, before I go to this, let's go back to the chats here. Right, going to quickly turn to the chats and see where I left off. There are some questions. A question here about consent for pictures. If you're going to be, there's a picture here about an image of someone who's passed away. Remember, POPI only applies to people that are alive. So once they're deceased, POPI no longer applies, and you don't need to concern yourself with POPI. So then consent and all those things, you don't need consent from family members or anything like that. If you've got a WhatsApp chatbot, again, please make sure they direct people very carefully to the right things before people start sharing sensitive information or things over your chatbots. Okay, you want to make sure that it's programmed in such a way that it directs them to a human being or some sort of secure environment before they start sharing things. I mean, I had a client recently whose systems were down, and they started automatically redirecting people to their Twitter page, I think it was, or Instagram, or one of these social media platforms, to say, please just send your ID numbers to us on Instagram. Well, please don't do that. And I went ballistic and I said, please, please, please don't do that, because then we're posting things into a public platform. WhatsApp obviously is still encrypted end to end, and so it's not the end of the world, but you want to just prevent people sharing sensitive information over those platforms. There's some questions here about privacy notices and cookies and things. I'll touch on that when I do the processing obligations. There's another question here about how POPI is going to affect websites and subscribe letters for newsletters and domains. Briefly on direct marketing, and it's an entire 3-hour topic on its own. Where you have people that are already existing customers, or you've obtained their details in the context of a sale or a transaction, you don't need to give them new opt-ins. You must obviously give them opt-outs. Where you are trying to garner new business, then you need opt-ins. When somebody comes onto your website, then they may very likely be designated as someone who's come across your details in the context of a sale. And so in those instances, if they populate, for example, their details into a query with you or a quote, you may obviously, barring some exceptions, and I'm speaking in general terms because I'm saying it's a very long subject in itself, you may be able to use that information. Right, then, yes, somebody said on the DM comms, we're happy to send us your details. You're talking about an image here, Celestine, where people are not obviously recognizable. So remember, anything that is unique to a person. So an image where you cannot recognize people, for example, if it's my face blurred out, possibly that's fine, but I'm not sure exactly what you mean by that. But if you are sure that an image can never be linked back to a natural person and it's completely de-identified, and go and have a look at the meaning of de-identified in this act, we can possibly get around it. Cloud storage, very important question here, Johan. Cloud storage is a very problematic area world around, because the big players in the market, if you're going to send them your 2-page operator agreement, I can assure you they're going to write back to you or ignore you and just say thanks, but no thanks. So what's happened in Europe, for example, is the regulators there have stepped in, and they have agreed standardized terms with the big players in the markets. Please go on to it's called the EDPB, the European Data Protection, whatever they are, I can't think what the last one is, board or whatever it is. They have standardized terms publicly available, particularly for Google and Microsoft and those kind of cloud storage service providers. So in theory, the terms provided to you should be reflective of those terms. We obviously want our regulator to do a similar exercise, but the most important thing you can do with a cloud storage service provider is mandate to them your security measures that you want in place, okay? It's very important that you stipulate the security measures. You can't have an Amazon web bucket that isn't password protected or encrypted, okay? It's left open. I've had a number of clients who that's happened to. Amazon is not going to say to you, configure yourself in an X, Y, and Z fashion. You must configure how you want it. You must tell them when they must delete information. So that is where you become important in that relationship. There's a comment from an anonymous attendee here dealing with biometric data. Please just, I'll touch on it when I deal with prior authorization and use of unique identifiers and data washing. But biometric information, please be very careful, have consent if you can, because it's something we just need to be very careful with. There's a question here from an ISP doing promotions. You're not able to disclose privacy policies on the street, unfortunately. A privacy policy, so if you have a flyer or something you're physically handing out, have a link that says you can find our privacy policy at abc.com, and please have on your website where it's publicly accessible if you have a website. There's a question here of freelancers, operators. Depends on the situation. I don't want to say definitively yes or no. Depends what the freelancer is doing. If they're a consultant or an independent type consultant, they may be responsible parties. But if they're doing a particular task for you where you're dictating the parameters, they could be operators. Lisa, operator agreement, what a nightmare. I agree. Couriers, web hosting, ISPs, invariably all those examples are exactly right. How do you get them to oblige? Well, scream, shout, and swear as much as you can. But what we've tried to do on our end, at least from an ENS perspective, is we've tried to develop a very short operator agreement. You don't want to be overwhelming people with a 30-page document, okay? 2 pages, short, quick, and easy, with a covering letter that says, this is why we need this in place. Hopefully that gets the trick done. You're welcome to contact us if you need help with that. There's a question here about Nalwazi. Is an operator the same as a third party? So e.g. IT person for an online guest list, very likely. So an operator will be a third party independent from your organization, but remember particular to processing of personal information on your behalf. Zoe, another question on marketing. I'm going to skip over that at this stage. Sorry, just because of the interest of time, just being mindful of how much time we've got. Erwin, I'm glad you think it's great information. Normally people get upset with me at this point and their heads have become overwhelmed by what's happening and I haven't even got to the meaty bits yet. You're talking about website privacy policies, PAIA manuals. You all have to have these. That's the problem. And I'll touch on why that is when I get to the processing conditions. Every company, big or small, has to have these documents in place. At ENS, for example, what we've designed is an SME package where it's meant to be cost effective, where all these items I'm talking about this evening are part of this package. We give it all to you. We talk you through the implementation, and we try and be very flexy on our price that you can become compliant quite quickly for a cost-effective price. So welcome to get in touch with me after this on that. Social media legal risks. Neo, we could spend an hour. Maybe we should. Obviously, it's difficult. Social media platforms are being very closely scrutinized by regulators world around at the moment. You're talking about Canada here, Erwin, as well. Remember, each privacy policy has to cater to the particular laws of that country. So some countries will have if you've got a global organization, they will have a more generic policy, but they may have annexures particular to each jurisdiction. You can sometimes merge the various jurisdictions' policies. We often do that for our clients, that they are both GDPR, Canadian, Australian, New Zealand, and South Africa compliant. We even have ones where we're dealing with places like Israel and Lesotho, believe it or not. So there are ways to cater for that. But please don't use something off a Canadian website for your South African stuff. It may not comply. I'm going to do one more. Megan, sorry if I'm mispronouncing your name. Can your region and your company check CCTV videos to see if you work or not and share it with one of the workers? Depends on your company's terms. In theory, yes, but it would entirely depend on what your HR terms are. Okay, I'm going to turn back to the slides now. Right, Mandisa, just indicate to me, are we back on the slides here?
Yes, we are.
Thank you. Okay. Right, so we're looking at who can go to jail. Well, the answer in short is your information officer. But don't get worried about that. Don't panic. I'm going to talk you through what that actually means, the limited instances that could mean. But let's look at the information officer. So who is going to be your information officer, and what are the requirements for an information officer? What are their obligations? What do they need to do? Okay, so the head of an organization, the CEO typically, is invariably going to automatically, by operation of law, be the information officer. So even if you don't appoint one and don't register one, the head of your company, the CEO, if there's one director, that person, if it's a trust and it's got a sole trustee, the head of your company is going to be the information officer, okay? That role may be delegated. The information regulator has confirmed you can delegate that role to someone else, but the liability is always going to remain with the information officer in terms of law. I don't know if, strictly speaking, that's correct. I'm not sure the Act provides for that, but for now, until someone fights the regulator on that aspect, that's how it remains. I look forward to having that fight with them one day and seeing where it ends up. But in any event here, what we sit here is that the CEO is going to remain liable, even if the role is delegated to a deputy or to another information officer within a company. You can read over this in time. I'm just going to gloss over it quickly for the interest of time. I want to finish on these slides before we get to the 1 hour mark. So what are the roles and duties of an information officer? What do you have to do if you on this call tonight are an information officer, or you're not sure who needs to be or what they need to be doing? This is the role. This is what your duties are. First thing you have to do, put on your pom-poms, become a cheerleader, and encouragement of compliance doesn't just mean singing a nice happy dance. It means achieving compliance, okay? It means putting in place something to achieve compliance. So you can see here, it's not just encouraging compliance within the body, it's also achieving and ensuring compliance with the provisions of POPI. So you want to comply with these 8 processing conditions that I'm going to get to next, okay? When the regulator comes knocking on your door because it's received complaints, and just remember, importantly for POPI, anyone can complain to the information regulator about you. It doesn't have to be an affected data subject. So if your competitors are angry with you, they could run off to the information regulator. Now, I'm not sure whether the information regulator's office is going to have capacity to deal with the volumes of things that are going to come their way as of next week. But in theory, if the regulator wants to do an investigation, they're going to liaise with the information officer. So you have to be in a position to do that. When we touch on the processing conditions, we're going to look at data subject access rights and what they may ask for. When these requests come in, you are liable for making sure that those requests are responded to, okay? So please remember, you can delegate that to deputies, but ultimately that liability is going to rest with you. You must develop a compliance framework. What does that mean? This word is touted about, compliance frameworks. Well, the regulator is as clear as mud on that. They say, you go away and figure it out. In my mind, a compliance framework is a checklist. It's a heat map. It's a spreadsheet. It's something that says, this is what I need to do to comply, and this is how I track my compliance against this. You can be as creative as you want with that, but put in place a framework that says, I have done X, I still need to do Y. Okay. Now, interestingly is this aspect. The Act itself doesn't mandate that we have to do what is called information impact assessments, or they call it POPI audits or POPI questionnaires. You'll have seen these bandied about in the market of it. GDPR mandates it, but indirectly through the information officer's duties, it imposes a duty on you to do these assessments. So what we recommend you do is you get your staff members, or at least some senior staff members, or if you're the sole staff member, you do it, to fill in a very short questionnaire. We have those templates. If you want to contact us for quotes on these SME packages, please do. You complete the template and you file it away. You do it on an annual basis or twice a year. That is going to tell you what your red flags are, where you deal with special personal information, where you deal with CCTV footage, where you do direct marketing and what you need to be mindful of. It's going to just give you some touch points to look out for and be mindful of, that you know what aspects you need to address from the information you process. What else does the information officer need to do? Our information officer has to develop internal measures to deal with the access requests. Okay, we spoke about it. Remember, you've got to find some sort of way to deal with these access requests that I'll deal with shortly. Training becomes very important. Training and awareness, okay? You have to make your staff contingency aware of POPI. However you do that is up to you, and you have to train people on what to do on this act. And you have to be able to demonstrate to the regulator, if they come and do an audit, that you've done training and awareness. So remember, tell people you've attended this seminar, and find a way to do training for your organization as well. I've said that ENS does a number of these seminars. Send your staff to them. Very happy that we book you into some of those training sessions. We often do free webinars and the like as well, but try and find a way to do internal training and awareness. Okay, these are just the fees for the information requests. Don't worry too much about it. But then very importantly are PAIA manuals. Now, PAIA manuals are a very strange component because there's a bit of a misconception in the market at the moment, because currently the PAIA Act, which is our Promotion of Access to Information Act, which is the sister act to POPI, and again, I'm picturing Whoopi Goldberg. But PAIA, importantly, prescribes that you have to have a PAIA manual publicly available at your head office and on your website. Now, there are certain categories of parties that are exempt from needing PAIA manuals, and I think it's generally companies with less than 50 employees. That is currently with the Human Rights Commission, these powers, and they transfer to the hands of the information regulator on the 1st of July. So if you've got a small company, don't worry so much, but actually it's a really easy thing to comply with. Getting a PAIA manual in place and putting it in place is a really simple thing to do. And it's better to have one than not have one, because these exemptions may not be extended in the way they should be, as they've been promised until January of next year. So please just look at getting a PAIA manual in place if you can. Remember, if you don't have a PAIA manual, it's one of the few areas where your information officer can go to prison. Okay, so when is your information officer liable? And then I'm going to turn back to the Q&A. So there's fines and imprisonment. Really, in my mind, it's three limited instances. One, if you don't have a PAIA manual when you have to have one. Two, when you try and bribe the information regulator. Please don't do that. Lastly, when you try and obstruct any investigation. Okay, so really you've got to do something quite serious to get it wrong. So otherwise, don't panic about criminal liability. The civil liability and the fines and penalties are something a little more concerning. The criminal liability, less so. I tend to say if our politicians don't go to jail, then what's the chances of our information officers? But maybe we need to be careful, and someone's luck runs out somewhere. Okay, so what are our practical considerations here? Think about it. Who is your information officer? Who's going to be your information officer? Very importantly, when you delegate deputies or when you delegate powers down, make sure it's someone that's really good with admin. Okay, someone that actually responds to emails. You know, we all have or know those people that have 1,000 unread emails in their inbox, and it doesn't drive them mad. It drives me insane if I have one that I can't find that's unread. So really you want someone that's good with admin, that's very good with responding to things and following up with those kind of things. Otherwise, outsource it where need be. What I recommend, again, I've said to you, consider some data champions, spread it across your organization. So if you've got an HR and IT department, make someone in HR responsible and someone in IT just to share the load. Register with the information regulator on their website. As I've said, there's been a myriad of teething issues, but we've got some breathing room on that. So some of the documents in the toolkit that is part of the SME offering is our authorization letters for the information officers, and I'll touch on these other things as well in a bit. Okay, I'm going to pause the share there and turn to the Q&A. I'm sorry, if there's anybody putting things in a chat box, I'm not looking at those. I'm only looking at the Q&A section. So if you are pasting things in the chat, please just pull it over into the Q&A section. I don't want to miss your questions. I'm not trying to ignore you. There's a question here on restricted data center regions for cloud storage. I'm going to get to that when I do transport of flows of information. An information officer can never be a juristic person, okay? It can only ever be a person. So you may appoint somebody to act on your behalf as an information officer, and we do see it being outsourced. I'm not sure yet what our regulator is going to do with that. In Europe, certainly the role of a DPO, a data protection officer, can be outsourced, but our information regulator is not loving that concept at the moment. So we're not yet sure, but your deputy information officer has to be an employee, okay? You're asking here, Erwin, about categories based on business turnover. Nope, there is absolutely no exemption for small turnovers. And it's interesting because some of the countries do cater for that. For example, Australia, I think if you have less than $3 million of turnover, you don't have to comply with their data privacy legislation. We haven't taken that approach, and I share your frustration. Our information regulators should be helping SMEs to comply. They should be doing trainings and giving them some kind of freebies and some kind of budget, not budget, but precedence. But they're not. I mean, we did see in Europe, particularly in the UK, because the UK also applies to all organizations, irrespective of size of employees or turnover. The Information Commissioner's Office there tried so hard to help the SMEs. Our information regulator just isn't taking that approach, and it's a tragedy because everyone has to comply. So I do sympathize with you. There are some companies out there that are offering really cheap compliance packages for 4,000 or 5,000 Rand. I can't comment on the quality of those packages because I haven't seen them, but maybe it's worth investigating if you are very cash strapped. Jennifer complaining about ISO and you've got to stay compliant at POPI. I know it's very nerve-wracking. And I think the first year or two of this is always difficult. You know, we always get a little bit nervous and a little bit concerned about how we comply until it starts to become normal. And remember, I always talk about POPI compliance as a journey. It's not something you can achieve overnight by ticking 6 boxes and you're there. And anybody that tells you can do it is wrong. And if they tell you that you can get a POPI compliance certificate, they're wrong. POPI compliance certificates are not a thing, guys. Don't pay for them. Don't spend your money on it. It cannot be given. It cannot be done. Okay. Then you're asking, are there any SAQA accredited courses? And I'm going to just excuse my ignorance. I don't know what SAQA stands for, Jan. So if you can give me a little more information on what that is, somewhere in the chats, I'm happy to figure out what it is. If you're looking for accreditation, I see there is something in the chat here. I'm just going to quickly pop to the chats to cover these because we have 5 more minutes before we're on the hour mark. Right, somebody's asked me for the recording to be available. So I'm sure Mandisa will circulate the recordings to you or deal with those logistics, and I'll let her answer that towards the end. Just checking if there's nothing I haven't covered, it looks like. Erwin, there's one more thing you've popped here into the chat, which deals with companies abroad have policies. Again, GDPR doesn't address the SA environment. We've spoken about that. Okay, so that's about everything. Anything I've missed? Here you've said non-profit organizations. Non-profits likewise have to comply. So for example, what we do at ENSAfrica is we do a lot of pro bono work for non-profit organizations. And we help them everything from the Solidarity Fund to the gender-based violence funds. We help them for free to get compliant because really there's an ethical duty on attorneys to do pro bono work as well. So if you are a non-profit and you feel like you qualify, drop me a note. Very happy to run it through my pro bono committee and see if we can assist. And then Erwin will pop the basic costs across this with a discount for SMEs after this session. Right. Going to get back to our slides. Okay, hope the slides are back on. If they're not, let me know. Right, so I've spoken a lot about the 8 processing conditions, and if these are the 2 slides you want to print at the end of this and stick up on your wall, this may be the thing to do. So when we deal with POPI, there are 8 things we have to do. Okay. 8 rules, 8 compliance functions, 8 tick boxes. And tick boxes are a very easy way of summarizing what is actually quite complicated. But I'm going to try and keep this as simple as possible for you. First one, First one is self-explanatory, okay? Responsible parties must comply with POPI, and you're compliant, you're liable, and you've got to be able to demonstrate your compliance, okay? So that's where our compliance framework comes in. Demonstrate what you've done as against compliance. And try and do something, even if you can afford, even if it doesn't cost money. Try and do something, okay, as against what you've learned here tonight. That if you do ever get in front of the information regulator, you can say, we've tried, and this is how we've tried, and this is what we've done in order to try and comply. 2, 3, and 4, I'm going to try and give it to you in a, I don't want to say a one-liner, but lump them together. Okay. I find it's easier to start with 3, and I wish 3 came before 2, but I didn't draft the act. So don't blame me. First thing we need to know, you may only process personal information when you have a lawful, valid reason to do that. Okay?
Sorry, Nicole. Sorry to interrupt you. The slides seem to be frozen. We're still on the POPI toolkit slide.
Oh, okay, hang on.
Okay.
Thank you for letting me know. Don't know why that is there. Okay, no, hang on. Let me stop the share and share it again. It's clearly my Wednesday evening brain. Okay. Are we on the same slide now?
Yes, thank you.
Does it say the 8 processing conditions?
Yes, it does. Thank you so much.
Okay, sorry everyone. Thanks for letting me know. Apologies for that. So 1 we've spoken about, 3 I'm touching on now. You must have a lawful purpose for processing personal information. And you must identify clearly for yourself what that lawful purpose is. We speak a lot about consent, okay? Consent doesn't mean you're now POPI compliant and you can do whatever you want because you've got consent, okay? Please don't confuse those issues. Consent means you have ticked 1 of the 8 boxes, okay? That's all it means. It helps us with some of the things I'll touch on just now. But it gives you your lawful basis for processing personal information, and it helps you with special personal information and those things. There are other lawful bases, okay? Things like it's in your legitimate interest. The law says you must. There's a contract. It's in the interest of the data subject. Okay, there's different reasons, but understand for yourself what that lawful basis is, why you process that personal information. Then we get to this principle, number 2, which is in Europe called data minimization, which I think is better than processing limitation. But it says that if you've got a lawful purpose, you must only collect that information which is strictly speaking necessary for that purpose. So I like to use the example of being a traveling shoe salesman. If I go around from town to town and I sell shoes, I may need your shoe size and I may need your home address to deliver the shoes. I don't need your previous underlying health conditions to sell you shoes, okay? So I shouldn't be collecting your health condition to sell you shoes, because that is where we get to this data minimization principle. Only collect as little as possible. And then 4 is closely linked to 2 and 3. So I know now I must comply. I must have a lawful purpose and only collect the bare minimum. Now I must say to myself, I may not do something new with the information that I've collected. Okay, that is called further processing. So if I collect your information to sell you shoes, I can't now go and sell your height, age, weight, and shoe size to a medical aid company for them to go and sell you life insurance, because they're going to determine from that whether or not you're going to die of a heart attack at age 55. That is called further processing, and there is a prohibition on further processing. So where we take information and we want to share it to do something different with it, we have to say to ourselves, was this in line with the original purpose for collecting the information? That is called compatibility. If it was compatible with the original purpose for collection, it is not further processing. We can carry on. But if we say to ourselves, hang on, we're doing something new, we need, in theory, in general terms, we then need consent from the data subject to go and do something new. 5, 6, 7, and 8, great. Just in case we didn't have 4 exhausting processing conditions behind us at 7 o'clock in the evening, here come 4 more. So 5 is information quality, okay? And you'll see what I've done in these slides is I've put reference here to the documents that you're going to need, okay? In general terms, to help you match back the documents to your conditions. Information quality, I should also have added to this record retention. The reason for that is because for as long as you keep information, okay, you are liable for that information in terms of it being up to date and of a good quality. So POPI doesn't say you may only keep information for 3 years. It says you may only keep information for as long as you lawfully may keep it. And for as long as you keep it, you're liable for looking after it and you're liable for keeping it accurate. Now, it doesn't tell us how we do that. It says you've got to put in place reasonably practical steps, whatever that means. Some lawyer drafted that term. But you've got to find a way to update your records or keep them accurate. So people say to me often, if I've kept information before 1 July, what happens after 1 July? POPI doesn't have retrospective effect, as in it doesn't apply to what I did yesterday. It doesn't apply what I do on the 30th of June. Look at me adding an extra day to June. But on the 1st of July, any record that is still in your possession, even if it's from 1960, you are processing that record. And so you become liable to keep that information safe and up to date and have a lawful purpose for keeping it, okay? So people are very, very sensitive and sentimental about records, and they never want to delete everything and they want to keep everything. But somebody applied for a job at my company 6 years ago, and what if they want to apply again? And can I keep that CV forever? Think about that carefully. Do you have a right to keep it? If not, get rid of the thing, because otherwise it's going to become a headache somewhere down the line. Then 7 I'll do next, just because I think it links closely to that. Remember, I've said you've got to keep it of a good quality, and I think Lisa or somebody asked me about ISO. Not only does it say keep it of a good quality, it says look after it, lock it up, keep it safe. Now remember, POPI doesn't only apply to IT records. It doesn't only apply to the digital world. It applies to physical records as well. Paper. Gosh, we love paper. Maybe not so much anymore. I've only become a paperless human being in the last 12 months, courtesy of COVID. But my office, at the office, which I never go to anymore, is still full of paper. Our physical records also apply when we cart files of paper home and we throw them away in our dustbins at home and we leave them lying around for everyone to see. Physical records, guys, please remember, they're as important. I like to use the example of logbooks. You know, when somebody comes to your premises and they sign in, and then above it is 35 other people's names that say, hi, Joe Soap and Sam Blogs was here. He has their ID number and telephone number publicly accessible for all to see. Those systems have to change, okay? They're not good enough. In fact, a competitor of mine in the market, and I love to use it because it never happened to me, they ran a POPI seminar pre-COVID, and they invited the information regulator to come give a presentation. And the information regulator had to sign in at their reception and could see everyone's names, and she called them out on it in the middle of the presentation, and it was awfully embarrassing for them. I'm glad it didn't happen to me. I love the example. But please be careful of these kinds of things. Physical records, printer policies, clean desk policies. These are the ways we achieve organizational measures. Then we turn to technical measures. Okay, organizational measures are really easy to achieve without incurring phenomenal costs. If you've got printers, put a password on your printer that it's password protected, that no one's printing is just lying around. If you've got information, lock it in a safe, put it away where not everyone can access it. Please, these are things that you can achieve that are very cost effective, that no one's going to give you any forgiveness for. Technical measures, again, no one's going to tell you what your security safeguards must be. No one's going to tell you, you must use this gold standard ISO certification, or you have to do penetration testing and encrypt your stuff. You determine for yourself, in terms of your financial means and the type of information that you use and the volumes of information that you store, how you look after it, okay? Whether you're going to password protect, whether you're going to use multi-factor authentication and VPNs, whether you're going to encrypt information. Very importantly, how do you back up your information? Okay, do you allow things like flash drives and hard drives and external drives onto your systems? Do you let your employees connect with their own devices? Do we use C drives and let people download off our systems? These are all things you need to say to yourself, and you have to think about it. If you're a one-man band running around with your iPad, make sure that iPad can be remotely wiped. Make sure that information is securely backed up, not linked to your main information, so that if it does become hacked or compromised, you've got a backup system. If you do lose the laptop or iPad, you can wipe it remotely, okay? Make sure it's got a good password. If anyone has a 1, 2, 3, 4, 5 password, jump off this call now and change the password, then jump back in, okay? Make sure you think about things. And please, if I can implore anything on you on security safeguards, change your passwords all the time. We never do it. We keep passwords for 100 years. I nag people in my life all the time. Every 3 months, our personal passwords must change, even if it means you change 6 to a 9. Change them, reset them on your Gmail accounts, on your personal accounts, your phones. Please, please, please change these passwords, okay? Go onto a website like Have I Been Pawned? Put in your Gmail accounts, put in your LinkedIn accounts, put in your work email accounts, and see how often your information has already been breached in the marketplace, and change things, okay? 6 and 8, last two, it's a mouthful. We spoke about privacy policies, okay? Privacy statements. You are required to tell data subjects what you do with their information. If I send information out to Kazakhstan, I must tell my employees, for example, if it's their information, or my clients, that I send information to a country out of South Africa that doesn't offer similar protection. If I send your information to external payroll administrators and IT service providers, I need to tell you that. I have to be open about what I'm telling you, what I'm doing. If I use your information for direct marketing and sell it to third parties, I must tell you that, okay? If you don't tell people these things, you're going to be in trouble. Please make sure you've got a privacy statement. Please make sure it's actually reflective of what it is you're doing and not just generic wording. Lastly, data subject participation rights. Remember, your data subjects are afforded with rights to ask you, what do you have about me? What do you do with my information? Please correct or update my information. Or please delete or erase my information. Now remember, your right to deletion is not absolute. I would love to write to Absa Bank and say, Absa, please forget about my home loan, but Absa Bank is going to laugh me straight out the door, the virtual door in this instance, because if there's a right in law to keep someone's information, you can do it. Remember, for direct marketing purposes, if they opt out, the opt-out is a hard opt-out, okay? Unless you've got a contract with them where there's a sale going on or something. If somebody opts out of direct marketing and you have to give them an opt-out, please. We've spoken about not needing an opt-in with their existing customers, but you must give people an opt-out. If they opt out and they ask you to delete information, you must comply. Okay, just to add insult to injury, this is one of our biggest fines ever. It was a recent fine. What happened here is, in France, they found that Google was not transparently communicating what it was doing in terms of its data processing for adverts in this instance. And they said users are not able to understand what processing operations are being carried out by Google. Not only in France, now in Australia and in London and all these places, they're in the microscope. But what I'm trying to demonstrate with this example is that you can't leave people uninformed about what you're doing with their information. It constitutes a violation, and you want to make sure that you comply. Right, on that, going to deal with another breach, just to add some more insult to injury. We're talking about monitoring employees. Great topic. Here we saw H&M monitoring their employees. We've seen it again with a number of big companies that were not doing it compliantly, so they were doing it. But importantly, what they were doing here is they were actually monitoring it to create profiles, to influence the decisions of their employment. Okay. So now we're using this for profiling purposes. So we're doing something else with our information. So it's not monitoring for an employment particular to that contract perspective. It's not checking whether someone's fraudulently falsifying things. It's actually trying to influence their decisions. Very naughty of them, without telling them, without getting their consent. I'm going to pause the share there, and I'm going to turn to questions. So, Johan, you've qualified your statement for me. I actually don't know what is out there. I know that some of the institutions do probably give some POPI courses. I see a number of things coming through on almost a monthly basis, but targeted to particular audiences, where they give you almost participation certificates, but I'm not actually sure what's out there. If you find out, let me know too. I'd love to know. Lisa, you're asking about member databases and liabilities. Heritage Club, wine clubs, same thing applies. If it's a family club of like, okay, it's my book club for a Friday night, then it's for personal use, and obviously it's irrelevant. But loyalty clubs, all of these things have to comply. So all of these guys are scrambling to get POPI compliant. And for existing members, it's mainly in simple terms. They just need to give you an opt-out. So what I've seen is a number of people writing to me saying, please opt in. I'm thinking that's very silly, because opt-in becomes tricky, and then we get stuck. Linda, very important question about information in the public domain. So people tend to think that information in the public domain means that POPI doesn't apply. POPI still applies, okay? All that changes if it's in the public domain. So special personal information, children's information, the information that we generally need consent for, if it's deliberately made public by that data subject or a guardian on behalf of a minor, you wouldn't then need consent to use it. But you still have to disclose the source of your information in your privacy policy. So just remember, because it's in the public doesn't mean POPI doesn't apply. It means there's more relaxed rules around it. Does government have to comply as well? So yes and no. Government does have to comply, but there's a lot of carve-outs for them. A lot of exemptions, a lot of areas where it's softer for them. Question on, do you have to dispose former employees' information? No, you don't have to do that. You may have consent to keep it, but remember, there are different laws in place that obligate. We can't just look at POPI and say, okay, we'll throw everything out, baby with the bathwater, whatever the saying is. There are different laws that mandate that we keep certain information in place for set periods of time. For example, tax legislation, occupational health and safety legislation. That mandates that we keep information, for example, for 10 years, but we must dispose of the records that don't, strictly speaking, fall into those lawful reasons to keep it. And after a period of time, you should be getting rid of the records you no longer need. Any other questions at this stage? Anything I've missed out on? I'm going to just quickly turn to the chat function in case there's something. There's a question here about where you can check if you've been hacked. It's have I been pawned, P-A-W-N-E-D. If you Google it, it'll come up and you can check your information there. It's very interesting. Right, going to head back to the share. Mandisa, just to confirm that this H&M slide is still up in front of you.
Yes, the H&M slide is still up.
And is it moving?
Yes, it is.
Good, right, we're all on track, and Wednesday evening brain is not taking over yet. So this is just to give you a group task, but you're welcome to look at it, take these back to your companies, work on it. This is talking about information sharing, okay? Somebody phones you, he says, hi, I work for your client ABC Incorporated. Please, can you give me all the information you have about ABC Incorporated? What are you going to do about it? What are you meant to do? Are you meant to verify? Are you allowed to send it to peter@gmail.com? Okay, remember, scams exist. all I can say is put in place verification processes from a basic perspective. What is happening so often, and more so, I deal primarily with data breaches. It's what I do on a day-to-day basis. I deal with when things go wrong. A lot of my colleagues that I work with deal with more of the compliance side, but I look at unscrambling the eggs, so to say. And what we see a lot of at the moment is business email compromise attacks and man-in-the-middle attacks. And since we've been working from home, they've increased by an astronomical figure, where emails are intercepted, account details are changed. These are all things that are a real risk to your organizations, okay? So please put in place verification systems. Make sure you know who your contact people are at any organization, that you don't end up disclosing information about company A to a fictitious person. Just to give you some examples to think through. Same here, actually talks back to the question we asked about earlier. Somebody phones you and says, hi, I used to work for you, please delete my information. Again, you only have to delete what you're not legally obliged to keep. Okay, remember, you must be aware of what your legal obligations are in law to keep certain records. Right, moving swiftly along, we're going to get to trans-border. I'm going to deal with trans-border and prior authorizations before I take more questions. So as we go, pop your questions into the chat again, or the Q&A. Sorry, I should stop saying chat. And I'll get to those. So what does POPI say to us? There was a question earlier, but here it comes. POPI says you may no longer send personal information out of South Africa. Well, whoa, what does that mean in this day and age where we send information? Our cloud service providers, our IT systems, our holding companies, our customers and clients, everything sits overseas. I mean, I don't know of a single company that doesn't, to some extent, use an application or an operator or have some sort of client or customer that doesn't sit in another jurisdiction. Okay? So how do we get around this? What are we going to do? First thing, okay? If you have consent of your data subject, then you can do trans-border flows without thinking twice. So when we say consent is key for only processing condition 3. Wow, now I'm rhyming. But also consent gets you over this hurdle. Okay, if you have consent, you can do it. If we don't have consent, what then? Well, then we say, is the third party that we're sending the information to, are they subject to a similar law that gives adequate protection? Well, remember right at the beginning, I spoke about juristic person data and how that forms part of POPI. You're not going to find another piece of legislation in the world that provides for juristic person information. So we're never going to meet that test. For natural person information, anywhere we're sending to European countries, for example, we'd likely be able to say they're adequate because GDPR gives adequate protection. New Zealand is adequate. Canada would be adequate. Argentina and Uruguay, I think it is, are adequate. So there are some adequacy decisions we can rely on. Our regulator hasn't given us adequacy decisions, and they've said they're not doing that anytime soon. Go off and figure it out for yourself. Thank you, very helpful. The other way around is we can put in place agreements with those third parties that they protect our information in a similar fashion. So if we're in a group of companies, we put in place binding corporate rules, or we put in place binding agreements. I spoke earlier about cloud service provider operator agreements. That's exactly what that's going to achieve. It'll allow for the trans-border flow without consent, achieving these kinds of principles. So go and look for those agreements. Spoken about consent. There are some other ways around it as well. Obviously, if it's necessary for the performance of the contract, you can do it. If it's in the interest of the data subject and they probably would have consented, it's also fine. So there comes the question, cloud storage, and I think we've answered it, and so we can move on. And prior authorizations have been deleted out of my slides, so I'm not going to deal with it. I'll just briefly touch on prior authorizations. Just remember that if you are in the business of data washing, if you use unique identifiers that are assigned to data subjects and you wash those against other people's databases And if you need more information, let me know. I'll very happily send you the prior authorization guidance notes from the regulator. You have to apply for permission from the regulator to be exempt from these things or to continue doing it. If you process, for example, volumes of children information that you send out of South Africa, if you do criminal record checks and those kind of things against other people's databases, you may need prior authorization. It doesn't apply to every company, and so we don't spend too much time on it. It may apply to you, and so just be mindful of that. Okay, I'm going to quickly turn to questions again. So just to pick up where we left off. Okay, nothing else in the chat function at this stage. Questions? I'm going to just go across to the chats and see if there's anything. I think I've exhausted you all. I apologize. Oh, there's somebody who's posted the "Have I Been Pawned" for us. Thank you. Erwin, you say here hacking should be covered in the privacy policy terms and conditions. No, because hacking is not something that you do. But where you suffer a breach, which I'll touch on now in the security compromises, there are certain things you have to do. I hope I'm understanding your question correctly. If I'm not, please just add some more clarification there. Right, that seems to be everything in terms of comments and questions. Am I missing anyone's questions at this stage? If so, pop it into the Q&A and I'll get to it. Just double checking in the Q&A box. Right, all seems to be okay. Right, so back to, and I hope the security compromise slides are back up, Mandy, so if they're not, just let me know.
Sure.
Right. So what is the data breach? What does it mean for us? Where are we going to get to with that? So very importantly, and I hope my breach slide is up, the slide that says defending the breach. If it's not, just shout.
Yeah, defending the breach is up, Nicole.
Cool. So what does it mean for us? Now, POPI, in case it wasn't onerous enough for all of us, has this added sting in the tail where anything that goes wrong virtually must be reported. So section 22 of POPI says the following. It says any time that you have reasonable grounds to believe that personal information, and remember how widely defined personal information is, has been accessed or required. Okay, accessed or required, not defined in this act, give it its ordinary meaning, by any unauthorized person, it constitutes a data breach. Okay, constitutes a security compromise. So before I turn to what that means, let's talk about what that could be. If I, for example, am meant to send an email to Mandisa and I send it to somebody else and it attaches personal information belonging to another one of my data subjects, that is a data breach. If I have a laptop that's stolen that's not encrypted, that is a data breach. If I lose a file of papers with personal information, that is a data breach. So it's not just being hacked, it's not just ransomware, it's not just business email compromise and man-in-the-middle attacks. Those things happen all the time as well. So please reset your accesses frequently and check that you delete people's access when they leave. What I see frequently at the moment is employees that are angry with you, trading your information. That is a data breach. Okay? Very widely defined. Now, very importantly, why do I say this is a problem? You never, ever, ever have to ask the question as to whether or not you think there's been harm or possible harm to data subjects before reporting this breach. Every other piece of legislation world around, except Turkey, interestingly enough, for those who wanted to know, require an anticipation of harm to your data subject before you report the breach. Not here. So we've got very onerous breach reporting provisions, okay? Now, when a breach happens, what do? Firstly, the Act says you have to report it as soon as reasonably possible. So there's a quick turnaround time. And as soon as reasonably possible is as clear as mud. So in case you're wondering what that means, well, we'd love to know. All I can say is it depends on how serious the breach is. If you think there's possible harm or severe harm, report it ASAP. Okay? That's what's going to determine that. The notification, it's comprehensive. It has to include things like who's been affected and how, when you found out about this, what do you think the possible ramifications of the breach are? What have you done to mitigate the breach? Okay, how have you prevented this from ever happening again? Well, I don't know how we're going to tell somebody that in a quick turnaround time, but okay, fine, we'll tell you what we can. And remember, it must go to the regulator and to the affected data subjects, your notification. The only time you don't have to notify data subjects is when there's some sort of criminal investigation or the regulator says don't notify them. Okay. So what are our practical considerations here? What do we need to say to ourselves? Own devices. Own devices are wonderful things. People logging onto our networks, us logging onto our own networks, or we run our business off our own computers. That's fine. Many small businesses do, many nonprofits do. But then we have to find a way to look after that information, okay? We have to find some reasonable ways to put some basic security measures in place, even if it's just changing your password frequently. Shredding documents. Well, this is a great case. I'll tell you about this example to Barclays in the UK. They were trying to get compliant under GDPR, interestingly enough, and they took records from the last 2 years and they popped them on the pavement outside for the recycling company to come by and pick them up. But the recycling company didn't get there first. Someone else did. And they took all these bank statements and they sold them for, I think it was £20 a pop on the dark web. And they were fined for being in breach in the way in which they shredded the documents or didn't shred the documents. Interestingly enough, the very first fine issued under GDPR in the UK was to a small pharmacy in London. It wasn't to a big company, it was to a small company. And what that pharmacy did was very similar to this, okay? They also took their last 2 years, 2016 to 2018 records, health records and patient records, popped them into the bin outside their premises, and those things were found by a member of the public who reported it to the Information Commissioner's Office. Now, because it was health records, it was found to be an inadequate way to dispose of those records, and they were fined, I think it was £260,000 or something like that, the very first fine. So just because you're a small company doesn't mean you fly outside of the radar. In fact, sometimes smaller companies are easier to find simply because they just don't have the means to defend these kinds of actions. And sorry, I'm not trying to scare you, I'm just giving you the facts. BCCing versus CCing, nice little way to commit a breach. We send an email to everyone and we CC 20 people's emails in it. Oh, my child's school does this all the time and it drives me insane. And if I've told them once, I've told them 10 times. Don't CC every other parent in, because then you're disclosing every other parent's record. But we all do it. We're all guilty of it. We've all done it. We often do a slip of the finger. We send the wrong email to the wrong person, attaching the wrong spreadsheet. Those are all offenses, guys, all things we need to be careful of. Old employee records. Oh, we love these. Job applicants, people that used to work for us. Sentimental records, I call them. We hang on to them forever. We love them. Right? Remember that these all present a risk. Don't just keep them in case. If you don't know why you're keeping them, you probably shouldn't be keeping them. So how do we protect ourselves? There's some documents in the toolkit, for example, password policies, bring your own device policies. So this talks about what we do around those security measures. And then an incident response plan or a security compromise policy. What do I do when something goes wrong? How do I respond to this breach? What are my obligations under law? Just some examples here. We've spoken about some of them, I think. But here you can see an email newsletter. They sent all the email addresses in the to field or the CC field rather than the BCC field. They were fined. Okay, so for all of you that posted things about email campaigns and things, easy way to mess up before we even look at direct marketing consents, let's check that. HIV clinic leaking data. You can see why that's going to be very, very difficult for people to deal with. Email addresses of patients. You can see some of those obviously deal with special personal information, health information, but this Dean Street one was obviously an easy thing to get wrong. British Airways, what happened to them? You can see hackers retrieve details, and this is a hack obviously, included their booking details, names, addresses, credit card information. They were given a big fine. In fact, the fine was, I think, initially about £160 million. But what they did is they pleaded poverty last year under COVID, and the regulator took the COVID economic situation into account and reduced the fine. We'll likely see similar things here. So if we get fines and penalties, it's something you can rely on if your business is struggling to say, actually, a fine like this will put me out of business. I think we'll get some leniency on those, at least I hope so. Ask yourselves these kinds of systems. You've been hacked. You come in tomorrow morning and it's month end and you've got to process invoices for payment and your entire system is encrypted with ransomware. What are you going to do? And don't think it won't happen to you. Pretend it will. It may. It does happen. It happens to all sorts of companies, large and small. What are you going to do? How do you back things up? What is your next step? Okay, these are questions you need to be asking yourself. Right, I'm quickly just going to check the Q&A. Megan, sorry, I'm still probably mispronouncing your name. If someone's found guilty or there's criminal offense on a person, can you do lie detector tests on workers? So yes, there's no reason why not. We recommend that you update your HR consent clauses to get employee consent to do these sorts of things. It doesn't mean you may not do it. It just means you may be faced with a bit more of a challenge from employees. If you've ever been in an employment dispute, you'll know that people will throw all sorts of things into a dispute pot. And so it's better to just avoid those disputes entirely. So I think even in terms of POPI, you'll still be allowed to do these things, but you're going to get employees kicking and screaming and refusing because of POPI, and then you've got to first have that fight before you can do it. So let's try and get those things done up front. Just checking in the chats as well here. Lisa, you're saying another huge problem, staff/committee members, NPOs that do not BCC when doing bulk emailing. Absolutely. And this is why training and awareness is so important. Tell people time and time and time again, please BCC, okay? Your own staff. You obviously can't control what the outside world does, but if they send you an email where they've CC'd you into a million other people, tell them. It's in contravention of POPI. You can't be releasing my information like that, okay? Somebody asks here about calendar invites. You can't hide them by normal means. Yeah, I haven't actually given thought to calendar invites because seeing how we do it, but you can send the calendar invite to a BCC address, so see if you can do that. I'm going to play around with that tonight actually and see how I come right, and if I come right, I'll pop you an email and I'll let you know. Okay, so the last topic for this evening, and I know you're all sitting there dying, wanting to go get a cup of tea or coffee or go to bed or have dinner, and thank you for bearing with us for this long. We're going to be another 5 minutes and then we'll turn to Q&A. Non-compliance, what happens when things go wrong, okay? I don't like to take the regulator's approach of scaring people with fines and penalties. It's not the right way to tackle it, but just know that when things go wrong, they can go wrong. There are ways we can mitigate it. There's ways we can argue down fines. But step one is you want to try and show that you've taken some steps to try and comply. I do think that it's reasonable that there'll be some leniency in the beginning phases, but after a while, that leniency is going to go away, okay? So what can the regulator do firstly? We've spoken about imprisonment for your poor little information officer, and that may be you on the line. But there's also fines of up to 10 million rand. There's factors they'll take into account determining those fines, and that will also be things like your degree of negligence and level of compliance and all those kinds of things. So if you are liable for something, at least you want to bring that figure right down for a number of reasons. But then where it becomes very interesting, and I think I touched on it earlier, and I'm sorry if I have or haven't, and I'm repeating myself, I've done POPI coming out of my ears for the last few days, so I forget which session I've said what to. But what we have here is strict liability, and I'm pretty sure that somebody asked that question earlier. It means that the responsible party is always going to be liable for the actions of its staff, for its employees, for its operators and third-party service providers that are operators. The data subjects who are affected by the breaches of this act can sue you for damages. The regulator on behalf of data subjects can do that. So what we might start seeing is class action suits, okay? We don't know what that's going to mean because it's not quantified, it's not capped, there's no set amount. But there's types of damages they can sue you for. The first is called patrimonial and non-patrimonial. Well, that's just a fancy lawyer term for out-of-pocket money expenses and emotional damages. Okay, that's what those two things mean. Interest and legal fees as well. But then this new concept that we've never seen before is introduced into our law of aggravated damages. Now, it's in the Australian law as well, and I'm watching the Australian law very closely to see how that's handled. There hasn't been too much happening in the Australian law in terms of class suits and those things, but they're picking up. And I think in the next 12 months, we'll have an understanding of what sort of fines and penalties have been awarded there. Because they're a common law country and we share some similarities in terms of historical legislation, we do look to see how that's being treated there, and that may give us an understanding of what this will mean. Otherwise, it'll be interesting to see what our courts do. But our courts, I think, may be reluctant to give punitive or aggravated damages if it can be dealt with in the ordinary sense. Our courts certainly have been reluctant in the past to award constitutional damages where they could have done so. So I'm not sure we have to worry too much about that. Last item for tonight. What are your must-haves? What do you have to do? Okay. So maybe I should have started with this and you could have dropped off for the rest of the call. But I end with it just to leave you. For those who stayed on till the end of it, this is what you need to do. This is the 1 July deadline. Some of these things have been relaxed in the last few days. So firstly, your information officer, register. We, as of until yesterday, had to have registered by the end of June. This requirement's been relaxed, but appoint and register so long, okay? Get a privacy statement and a privacy policy in place. Please do. Everyone needs these. Include a link to it in your emails. Our privacy policy can be found at abc.com. Put an email wording in those little disclaimer boxes we pop into our emails. Put it there. You must have a POPI compliance framework, okay? Put one in place. Draw it up for yourself based on what we've said tonight. Data protection policies. What does that mean? It means that you've got to have a POPI policy that tells you that you're going to comply with POPI and how you're going to comply with it, okay? Impact assessments. We spoke about this, POPI audit questionnaires. Remember, information officer, you want to be doing that if you've got more than just you as an employee. PAIA manual, make it available. Have some sort of indication or policy for yourselves how you're going to deal with data subject access requests. Conduct awareness and training, and then close off your operator agreements. And that concludes the formal part of the presentation, and thank you everyone for bearing with me. Over to last questions. Just going to quickly go to the Q&A section here. 2 questions from Lisa. She asks, in an e-commerce website with regards to privacy policy and payment gateways, is it sufficient to mention in the privacy policy that payment details are only accessed by the gateway? Absolutely fine. Remember, what you're trying to achieve with your privacy policy is just accurately reflecting what you're doing with people's information. So if, for example, you're going to be doing something beyond the scope of that with information and it's going to be transferred to a third-party payment platform, that's what needs to reflect in your privacy policy. Another question from Lisa, you're talking about being a website designer here, and you're asking what are your obligations regarding advising clients on cookie notifications. Cookie policies, we haven't got a lot of guidance locally, but I can assure you that cookie policies and tracking of location data under cookies becomes a very contentious issue. I mean, we had a client recently that was fined, a South African company fined in Europe, because what they did is they allowed for websites in Europe to advertise on their, so if I went onto this app, somebody selling tackies in Amsterdam could link onto my website and sell these kinds of products. And there was a complaint and a fine issued for that. So please just remember, have a cookie policy. If you use cookies, make sure your cookie policy correctly reflects what's happening. Make sure your privacy policy tells people that you have a cookie policy, okay? You have to tell people what you do with information. Just going through the last things. Jennifer, yes, it's really next week, 8 days as of today. Had a little laugh yesterday because the information regulator said 10 days to go, and we had to remind them that really it was 9 days and June only has 30 days. Right, I'm going to just quickly pop across to the chat function to see if there's any last chats. Some thank yous. Somebody on aggravated damages here. Yeah, I think what aggravated damages, you're saying here, aggravated damages then may compensate where the loss is exacerbated by the conduct, absolutely. So where you're reckless, grossly reckless, fraudulent, those kind of things, I can foresee that that's where it's going to be used as an absolute punishment tool. And yes, one more question came through on purchasing location data from cookies. You need to tell people that as well. Tell people, be open, be transparent. Then, Mandisa, I'm going to hand back to you. Just thank you very much again for the opportunity, and thank you everyone for joining and bearing with us through a very painful topic. I hope it's been insightful and useful.
Awesome. Thank you so much, Nicole. That was a lot of information and definitely so much of work that still needs to be done by all of us as responsible parties. So thank you very much for that. Thank you to everyone that attended as well. Thank you for all the questions. They were extremely helpful. So we will be circulating the recording of the webinar. We'll also circulate the slides that Nicole has presented this evening. And then, of course, if you have any other questions, please feel free to email us. You do have our contact details at the Innovator Trust. So from my side, just a big thank you to everybody. Thank you for attending. Enjoy the rest of your evening and good night.
Bye, everyone.
Bye.